got it.
Hello and welcome to this edition of the ABA Antitrust Division Member Spotlight, highlighting the section's members working in the field of antitrust and consumer protection. I'm Sagiv Kanik, a law clerk at the Fairfax County Circuit Court, and I'm here today with Sushrut Jain, a managing principal of Edgeworth Economics. How are you today?
Pretty good. How about yourself?
Amazing. Really great. Could you, just for listeners, could you introduce yourself a bit and tell us about your current position and practice?
Sure thing. So as you said, I'm a managing principal at Edgeworth Economics, which is a consulting firm where we do economic consulting work in several areas in corporate litigation that include antitrust, economics, intellectual property, damages analysis, general sort of commercial litigation. I'm also personally working a lot in the areas of consumer protection, so false advertising, damage analysis, and things like that.
Amazing.
And sorry, as a bit of a background, I've been doing this for a couple of decades, both as a consulting economist as well as a testifying expert.
Cool. What drove you to work as a consultant and expert witness? Like, how did you go from I love economics to I want to consult?
So I'll try to keep that brief, but basically, I was in graduate school in economics in the PhD program at Stanford University many years ago, working as an economist, studying industrial organization specifically. And while I was doing that, the more I did it, the more I was convinced that I wanted to work in sort of a more practical application of the field than in pure academia. And so I sort of started talking to people who had graduated from the same program as myself, and ended up speaking to a couple of people who were in the economic consulting world. And when you go into graduate economics at a place like Stanford, it's not really, even especially in those days, wasn't really on your radar we didn't even know something like economic consulting existed. But of course, the world of economic consulting has come a long way since then, and now it's definitely something that folks who are at PhD programs are considering as one of their 2 or 3 sort of potential careers.
That's fascinating. What does an economic consultant do for business entities and corporate clients?
So typically the work that so there are many different areas, but we work specifically in the context of corporate litigation. And so law firms that are representing entities involved in corporate litigation of all different types, where when they find that they require economic expertise to present their cases, they will often turn to economists either at academic institutions or at consulting firms like ours. Sometimes consulting firms like ours will also work to support an academic economist who will then be the testifying expert. But essentially, if you're in the area of something like antitrust, it's very easy to understand that the core of an antitrust litigation often tends to be economic issues. Were companies engaging in unlawful market power? Were they colluding with each other? The answers to these questions often are not purely legal. They actually involve, looking at the economic conduct of those entities, and that's where the economists come in. In other areas, such as say intellectual property damages or patent infringement damages, it may not seem as obvious, but in those situations, what you might have is on the liability side, you have sort of technical and scientific experts, judging whether a certain product infringed the technology of a patent holder or so on. And then the economists are brought in sort of assuming infringement, and then to try to analyze what the harm may have been to the plaintiff in a case like that. And there it's understanding the market, understanding what the market would have looked like had the bad act not occurred, and a lot of that involves economic analysis.
How do you prepare an economic analysis? What kind of information do you collect? Who do you talk to in these kind of cases?
So it's a wide variety of things, and depending on the scope of the matter, you may have all of those resources available or just a few. But for instance, one of the things you're doing is you start with the documents produced in the litigation itself, right?
Mhm.
And there's usually just a massive amount of documentation. Now, the lawyers will work to sort of cull that down to the set of documents that are relevant to the economist. But there still tend to be, sometimes thousands and thousands of those documents alone, internal company, uh, analyses, internal emails sometimes. That's one set of things, and then another set of things is just sort of research that's out there publicly available, including academic literature on the industry that you're studying, on the issue that you're studying. If it's something in the pharmaceutical world, then for instance, you're looking at a lot of economics, what economists have said about that particular issue in the pharmaceutical industry, just understanding the industry and how it works. So that's the public aspect of the research that you do, and over time you sort of build your own knowledge in a particular sector or an industry, so you're not starting from scratch necessarily. And then sometimes you have the opportunity to actually interview individuals involved in on either side of the issue. Sometimes you attend fact witness depositions. So there's a lot of stuff that you try to use as your basis.
Do you find that in antitrust cases or intellectual property cases, the information you need is very different, or are they still similar?
I think so. I think it's different. I mean, antitrust cases tend to be, especially if it's so. A lot of what Edward Economics does, and what I do, is we work on these very large, cases that are class actions related to price fixing allegations, for instance. 2 or 3 players in a particular industry are being, there's allegations against them that they colluded to fix prices artificially. In something like that, you have massive amounts of data, typically relating to the class period or, purported class period. And you're looking at price information, quantity information, different products, different regions, different competitors. And so that's the type of data you tend to look at in those large antitrust cases. And in intellectual property damages cases, yes, you will look at price and quantity data as well if it's available. But oftentimes, if the databases are not as huge as they might be in an antitrust case, it's hard to explain beyond that without getting too much into the weeds.
Right, and not to steal any proprietary information from Edwards Economics.
Oh no, it's not. None of this. What I'm telling you is not really proprietary. It's more about sort of there is a difference in patent damages cases and antitrust cases, and also I work a lot in the false advertising space, and there often the battle is occurring between economists at the class certification stage, and there's not often that much data even to go by. And there it's more, can often be more economic theoretical arguments that the experts are making on both sides, and so it varies.
Speaking about class certification, I saw that you developed economic models to analyze issues regarding class certification. Can you speak a little bit about class certification? What are the difficulties of certifying a class, and how does an economic model analyze that?
Sure. So, one of the things in the antitrust world, we look at is when you're trying to certify a class, the plaintiffs have to meet certain requirements for that class to be certified. One of those is the predominance requirement. And the predominance requirement basically means that do class-wide issues predominate individualized issues in this case? So in the sense that, like, we're saying everybody who bought this product was harmed, across the different states and different time periods and all of that, no matter where they bought it, whether they bought it at Walmart or they bought it at whatever, right? And the idea becomes, well, it doesn't matter who the individual is or what the circumstances of purchase were, let's say. What matters is what's common across the class. And we have a damage model that the plaintiff's expert might say that covers everybody. And that's why it's better for the court to certify the class than to let this case be broken up into thousands of individual lawsuits, right? Mm-hmm. And oftentimes what you find is the data might tell you otherwise. So for instance, the data might tell you that actually, if you bought this product in these particular circumstances at this time period or in this from this type of seller, that you may have been impacted less or not at all by whatever the allegations are. And so sometimes you analyze the data and you find that there are different types of buyers, different types of consumers, and that they don't really all belong in the same class. But it's hard to know that without having the data at hand to be able to analyze it, to be able to say, look, this is the variation across different sort of categories of consumers, therefore they don't belong in the same class. So that's often a battle that will happen at the class certification stage. In some cases, it's very clear that there are different types of consumers that don't belong in the same class. And other cases, it might be very clear, for instance, in a securities class, that everybody who was harmed by, say, the company's misrepresentation, they may all have bought the stock at a certain price or at different prices in a certain period when the truth was not known. And when the truth is revealed, the stock price drops. It's pretty straightforward that if you own the stock, you are probably going to be part of the class. But in other types of cases, like consumer class actions and price fixing class actions, that's not how it works. There may actually be many different individualized issues, and the class may not be the right way to go.
Thank you. I think that brings a little bit clarity to the topic. Switching gears a little bit, I'd like to ask about the interpersonal aspect of your work. Do you think do you have any challenges explaining economic data to counsel? Or how's that interplay between an economist who has a PhD and lawyers?
Yes, that's a great question. And I mean, I think that, we live in a world now where everybody is very good at the thing they do, right? So we're all so specialized that it's no surprise that, when we deal with counsel, even if they may have tons of experience in the particular type of, claim or litigation that you're dealing with, economics can often be a black box, especially when it gets very quantitative. And the challenge for us as consulting experts is to demystify that and to remove the black box sort of aspect of it when we're speaking to people who are not practitioners in the field. And so that is always a challenge. And, there are varying degrees of difficulty depending on the attorneys you're dealing with and the issue you're dealing with. But we take that on as a personal challenge. Like, ideally, the way I look at it is no matter what you're doing and how complicated it is, if you can explain it to someone who's not in your field, then you truly do understand it, right? Mm-hmm. And so that's something that I think is a skill that you develop over time, and we definitely pride ourselves in that. The people who know how to do that, I think they're valued highly.
Absolutely. Do you have any suggestions for lawyers? Obviously, you transferred information to the lawyer who then has to transfer it to a judge. Do you have any suggestions how they can better understand economic data and how they can effectively do what you do, which is explain it to the next person down the line?
Yeah, I mean, I think that the simplest way to do that. This may sound like I'm going to advertise here, but I think the simplest way to do that is to get the economic expert involved early. Mm-hmm. And to communicate with them often. I found that counsel will often face challenges when they wait really long in the sort of life cycle of the litigation to retain an economic expert, because at that point, all you can get out of them is get their expert report out and then the deposition and so on. You may not have enough time to sort of really pick their brains and understand what the issues are so that you can internalize it yourself. And so I think the best way to do it is to work closely with your economist and to have them on board as early in the process as you possibly can. But yeah, I mean, I think it requires sort of a continuing education in some ways for everybody involved.
Do you find that, and I imagine not, but when you have opposing economists and you have those depositions, what makes a good deposition of an expert witness in economics? What's more convincing to judges or to courts generally?
I mean, I think what I've found is you want to be very well prepared, um, not just with what you've done in your report, but also with the sort of facts of the case and the industry that you're talking about. And the more you sound like you have an appreciation for the facts of the case, and that you're not gonna, suddenly be surprised by the attorney who's deposing you, if he throws out a certain fact, says, well, what about this thing? And you say, I don't no idea, I've never seen that before. That's bad. And so preparation and steeping yourself in the facts of the case is a really good practice in general. But also knowing the limitations of your knowledge and your analysis, and not trying to, I think economists who sound like they're advocates, I think can often get in trouble and sound less convincing to courts. So you want to stay within your lane, and if things are coming at you where you're being asked to opine about things you may not be sure about or that are just outside your area of expertise, you can say, I don't know. It's always a good thing, always a good practice to do that.
Amazing. And now that we're speaking as part of the antitrust division of the ABA, how has your involvement in the antitrust section helped your practice? What have you been involved in? Are there any highlights that you've enjoyed as part of our section?
Yeah, I mean, I like attending the Antitrust Spring event. That's always been a fantastic event to go to, and you get to hear speakers on sort of the most current topics, coming at the issues from defense side, plaintiff side mindsets, the legal aspect of it, or just some kind of an industry expert. There's so many great speakers at those events that and you get to sort of see the other practitioners in the field and talk to them and get a sense for where the field is generally. And I think I really enjoyed that a lot.
I'm so glad to hear that, Sush.
Yeah.
That's it. I really appreciate you taking your time. This has been an ABA Spotlight series with Mr. Sushrut Jain from Edgeworth Economics. I really appreciate you took time today to speak with me.
Thank you so much for interviewing me, and great interview as well. Thanks so much.
Have a great day.
You too.